Hi, my name is Jane McElligott. I'm a full-time faculty member in legal support and services at Purdue University Global. And in our continuing series of SCOTUS videos, we'll be covering the National Pork Producers versus Ross case, decided just this past in May of 2023. And it involves a challenge to Prop 12, which is California's Animal Welfare Act. So a little more background on this act. So Prop 12 was passed back in 2018. A majority of California residents voted for it. In fact, 63% of voters. So it was a pretty major majority. So this act is also known as the Prevention of Cruelty to Farm Animals Act, and it requires minimal freedom of movement in confined areas. So, for example, for egg laying chickens, for calves, and this case in particular involves for pork. Pigs, especially breeding pigs, cannot be confined to gestation crates. And the reason for that is gestation crates are so small that the pigs can't even get up and they can't turn around. They basically can't move at all. And so it's a cruel form of confinement. And so, and the thing is, female pigs are just constantly, repeatedly impregnated. So most of their lives are spent in gestation crates. So California wanted to do something about that, make a statement, make it so that pork that is derived from pigs in these conditions cannot be sold in its state. So basically, Prop 12 prohibits this really unbearable type of confinement by mandating that breeding pigs have at least 24 square feet of living space. So that is enough room for the pig to turn around, to stand up, to lie down. And if that requirement is not met, that pork cannot be sold in California, even if it's produced in another state. So the National Pork Producers Council, who we will refer to as NPPC, challenged Prop 12 as a violation of what's called the Dormant Commerce Clause. So probably familiar with the Commerce Clause, which is in Article 1, Section 8 of the Constitution. And that's the provision that grants to the federal legislature, Congress, the power to regulate interstate commerce, so business, travel, transportation between the states. The Dormant Commerce Clause is sort of an addition to that, and it's been established by case law. SCOTUS itself has established it, and it limits the authority of states to get involved in any way in regulating interstate commerce. They can regulate their own commerce within the state, but not between its state and other states. So the NPPC's Dormant Commerce Clause argument contended that states like California cannot require out-of-state businesses to operate in a particular way in order to sell their products in California. So that was sort of the main gist of their argument. Justice Gorsuch wrote the majority opinion in this case. There were several different opinions written by the justices, but this one carried the day. So it was the opinion of the court, and the court upheld Prop 12. And in doing so, upheld the state's ability to impose animal welfare requirements on any products that are being sold in that state. So Justice Gorsuch noted that in previous cases, in which the court did strike down a state law for violating the Dormant Commerce Clause, the justification really is to prevent what's called purposeful discrimination against out-of-state economic interests. So that situation where the state might pass a law just to give that advantage to in-state businesses to the detriment of out-of-state businesses. And of course, that has an impact on interstate commerce. So in order in this case, for NPPC to have a valid argument based on the Dormant Commerce Clause, they would have to establish that Prop 12 was driven by this type of economic protectionism. So really designed to bolster in-state business, California's own business, to the detriment of other states by discriminating against or burdening out-of-state competitors. And that's become known as the anti-discrimination principle. NPPC, though, failed to meet that burden. And in fact, they really didn't even try, because they basically admitted that Prop 12 treated in-state and out-of-state pork producers exactly the same. There really was no evidence of discrimination against out-of-state businesses. So NPPC didn't stop there, though. They argued that SCOTUS should go beyond the anti-discrimination principle and rule that the Dormant Commerce Clause bars any state laws that attempt to mandate how out-of-state businesses do their business. This was really far-reaching, and luckily SCOTUS knocked that down and said that, you know, no, there's no precedent for that, and that would have been a terrible decision if SCOTUS had gone that route, because it really would have negated the countless animal welfare regulations. There are many animal welfare regulations at both the state and the local levels that would have just been knocked out and would have had a huge impact on attempts to provide animal welfare. NPPC, again, it didn't stop there. They brought in another argument, and they contended that Prop 12 should be struck because the benefits of the law for California residents do not outweigh the costs it imposes on out-of-state economic interests. So basically, kind of bringing in this policy argument that just because California residents want to help the animals, that doesn't outweigh the cost it's going to place on pork producers. And the court said, that's not something, this isn't a task that a court is equipped to undertake. This is really kind of a policy decision. And the court even said in its own words, Gorsuch said, how is a court supposed to compare or weigh economic costs so that the added economic cost to pork producers, for example, against non-economic costs to others? So the residents in California who want to, do what they can to provide better welfare for animals. And so Gorsuch said, no, this is a policy decision, pointed NPPC across the street to Congress as the proper forum for debating these types of policy issues. And he actually voiced suspicion that NPPC brought this case to SCOTUS because it was an easier route, because only winning a handful of judges may seem easier than marshaling a majority of elected representatives across the street in Congress. So it's interesting that he didn't hold back, and he let him know his let the NPPC know his suspicions on that. So this ruling is a very positive ruling in the sense that it is one more step forward for farmed animals. It's, still there is a long way to go, but it is importantly an affirmation by the Supreme Court that states have the ability to impose these kinds of requirements for a product such as pork or eggs or whatever it may be to be sold in that state, that they have to meet certain welfare standards. If the court had gone the other way, it would have been a major blow to progress in the animal welfare area. On a less positive note, a negative note, NPPC unfortunately followed Gorsuch's suggestion to go to Congress, and once they did so, they began coming up with this bill called the Ending Agricultural Trade Suppression Act. So what they instead of looking at it as a law that requires more animal welfare, they are saying that this law suppresses trade. And so they were trying to get enough votes to get this passed. It would be a detrimental act because again, it would be a major setback to animal welfare. More particularly, what it would do is because this would be a federal law, the EATS Act would override state laws. So Prop 12, there's a similar law in Massachusetts known as Question 3 that provides more room for confined animals. Those two laws would be pretty much struck down because any laws such as those that mandate that animal products produced in states um, with higher standards would just be gone, because the EATS Act says that as long as those um, as long as the requirements in the state with the lowest standards are met, then those products have the green light to be sold anywhere. So in effect, this quote does a very good job of really highlighting the what this act is really all about. So basically, the EATS Act inflicts a bottom of the barrel framework on the entire nation, steering agricultural production, which of course includes pork, animal derived foods, to the lowest standard around. So if any one state permits the production or sale of a particular agricultural product, no matter how hazardous, low grade, or morally objectable. So, for example, the cage, the confinement area in which they're raised, um, every other state has to go along with that. So no one state can step up and say, hey, we want to ensure welfare for animals. All states would be subjected to the very lowest standard of any state under this federal law. So you can see that would be a major blow to animal welfare, in the sense that a lot of times we see you know, positive developments by one state, and then the other states start following along. There would be none of that under the EATS Act. So hopefully there is opposition growing. Hopefully that opposition will continue. But we will have to keep an eye on this act, because that would really undo the positive ruling in National Pork Producers versus Ross. And just a few articles I just want to point out too. If you'd like to keep track of this case and other cases in the area of animal law, there's a blog known as A Humane World, Kitty Block's blog. So it's the Humane Society of the United States. Always keeping up updated on interesting cases and legislation. Also, the SCOTUS blog is an awesome resource for all kinds of all issues of the law that are going up to the Supreme Court. And Sentient Media is another excellent source for animal law as well. And finally, that link down there will bring you to the actual case, National Pork Producers versus Ross. So with that, I conclude, and I will see you at the next SCOTUS video. Thank you.